Hello, viewers. Welcome back to Legalopolis. Friends, do you remember the famous Gucci versus Guess case? Back in 2009, Gucci sued Guess for copying its iconic logo designs. After a long legal battle, the court awarded Gucci $4.7 million in damages. Or take the Adidas versus Payless case. This one was massive. In 2001, Adidas sued Payless for selling shoes with similar stripes. When the case finally concluded in 2008, Adidas walked away with a staggering $305 million, one of the biggest trademark infringement payouts in history. Clearly, trademarks are serious business. But what exactly are trademarks? Why are they so important? And how do courts decide these cases? In this video, we'll break it all down. And so, let's get started. What's a trademark? How do people recognize your brand in a sea of competitors? That's where trademarks come in. A trademark is your brand's unique identifier. It can be a word, phrase, logo, design, or a combination of these elements. It sets you apart and makes your brand memorable. But here's the kicker. Trademarks aren't just for products. Services are also protected by service marks. Think of trademarks as your brand's superhero cape. They provide legal protection, build brand identity, and tell customers, hey, this is my product or service, no trespassing. TM versus R in a circle. What's the difference? When it comes to trademarks, there's a big difference between using the TM symbol and having a fully registered trademark with the R symbol. Let's break it down. Trademark, that is the TM symbol, means you are claiming rights to a trademark for your goods or services. You don't need to register it, just put TM on your logo or name and you're good to go. But here's the catch. Your rights are limited to the geographic area where you're using it. Think of it like saying, this is mine for now. On the other hand, registered trademark, that is R in a circle, is the real deal. Once your trademark is officially registered, like with the USPTO in the United States, you get nationwide protection and stronger legal rights, including the ability to sue for infringement. Only registered trademarks can use the R in a circle symbol. It's like giving your brand a legal shield. And here's the pro tip. If you are serious about protecting your brand, go for the registration. It's worth the effort. Now, friends, trademarks come in many forms, each playing a unique role in branding. Word marks are simple yet powerful. Think of Starbucks, Nike, Amazon, names that dominate their industries with just a word. But sometimes logos speak louder than words. That's where figurative marks come in, like Apple's bitten apple or Coca-Cola's iconic script, which are instantly recognizable even without text. Some brands go even further with shape marks, where the product's design itself is trademarked, like the Coca-Cola bottle's unique contour or Toblerone's triangular chocolate bar. Then there are position marks, which protect the specific placement of a logo or design, like the Nike swoosh always appearing in the same spot on sneakers. Patterns can also be trademarks. Burberry's signature checkered pattern and Louis Vuitton's LV monogram are classic examples of pattern marks. Even colors can be exclusive. Tiffany blue represents luxury, while McDonald's red and yellow trigger hunger and excitement. But trademarks aren't just visual. Sound marks also exist. Think of Intel's signature jingle or MGM's roaring lion, which are just as distinctive as any logo. Some brands even trademark motion marks, like PlayStation's button animation or multimedia marks where sound and visuals combine. And if you think that's futuristic, hologram marks are next level, with brands exploring Nike's holographic shoes or high-tech movie studio logos. With so many types of trademarks, words, logos, shapes, sounds, and even colors, it's clear that branding is more than just a name. But here's the thing, not all trademarks offer the same level of protection. Some are legally stronger than others, meaning they are harder to challenge and easier to defend in court. So, friends, let's dive into trademark strength and uncover which types of marks provide the best protection for your brand. To make it simple, we'll rank them from the strongest to the weakest. At the top, we have fanciful marks. These are completely made up words like Google or Xerox, offering the strongest legal protection because they are unique and have no prior meaning. Next are arbitrary marks, real words that have nothing to do with the product, like Apple for computers. These are strong because they create a distinct brand identity. Then we have suggestive marks, which give a hint about the product's qualities, like Netflix, that is Internet plus Flix put together, or Airbus, that is airplane and bus put together. These are still protected, but not as much as fanciful or arbitrary marks. Moving down the scale, we find descriptive marks. These simply describe the product, like Raisin Bran for a cereal with raisins and bran. They only get protection if they gain a secondary meaning over time. And finally, at the very bottom, we have generic marks, common terms like bread for bread or phone for phones. These get zero protection because they are too broad to be owned by one company. So here's the pro tip. The more unique your trademark, the stronger the protection. So if you are building a brand, get creative. Moral of the story, the more distinct your mark, the harder it is for others to copy and the easier it is to protect. Continuing from our discussion on trademark strength, let's now dive into another crucial aspect, trademark infringement. What happens when somebody copies your trademark? Trademark infringement happens when a third party uses a mark that's too similar to a registered trademark, causing confusion for consumers about the origin of goods or services. In the United States, trademark disputes are governed by the Lanham Act, a federal law that safeguards brand identities. While each country has its own trademark laws, the basic principles are generally the same across the globe. On the international stage, the World Intellectual Property Organization, that is WIPO, manages trademark regulations. Thanks to the Madrid Protocol, WIPO offers a unified system where businesses can file a single application to secure trademark protection in multiple member countries. Now, let's look at the key elements of trademark infringement. To establish trademark infringement under the Lanham Act, a plaintiff must prove the following. Number 1, valid and legally protectable trademark. The mark must be distinctive and either registered with USPTO, that is US Patent and Trademark Office, or established through commercial use. Number 2, ownership of the trademark. The plaintiff must demonstrate that they hold the legal right to the mark and its exclusive use. And number 3, likelihood of confusion. The defendant's use of the mark must be similar enough to mislead consumers into believing there's a connection between the two brands. With these elements in mind, the legal process ensures that brands can protect their identities and prevent consumer confusion. Now, let's move on to types of confusion in trademark law. When courts are deciding whether trademark infringement has occurred based on the likelihood of confusion, it becomes a serious legal matter. To determine if one brand is infringing on another's rights, Courts look at different types of confusion. Let's break it down with some real world examples. Number one, point of sale confusion, or you could say, oops, wrong brand. Now, this occurs when customers mistakenly buy a product thinking it's from a famous brand, but it's not. For example, imagine a fast food joint called McTasty that tricks people into thinking it's connected to McDonald's. The second type of confusion could be initial interest confusion or clickbait trap. This happens when a brand uses a familiar name to attract customers even though they realize before completing the purchase that it's not the real deal. For example, you are searching for, say, Superphone in your web browser, expecting a top brand web page to open, but landing unfortunately on a knockoff site. Number 3, post-sale confusion, that is fake flags. Even if a buyer knows they purchased a fake product, others might still assume it's genuine. For example, someone wearing knockoff sneakers that resemble Nikes could have people thinking they are wearing the real deal. Or number 4, direct confusion. This is the simple copycat scenario. This occurs when a smaller brand uses a similar name or logo to take advantage of a larger brand's fame. Imagine a coffee shop named Star Bean with a green logo and could easily confuse people into thinking it's Starbucks or in some way related to them. And number 5, reverse confusion. Now, this happens when a large company, which is a recent or a junior user, aggressively markets its product to the point that consumers mistakenly associate the junior user's dominance and advertising with it. For example, a small clothing brand named Blue Wave might get overshadowed if a major company launches Blue Wave sneakers. So friends, these are the types of confusion courts consider when determining trademark infringement. But why does this matter? Confusion harms both brands and customers. Whether it happens at the point of sale, online, or even after a purchase, courts take these cases seriously. So if you are building a brand, make sure you're not stepping on anyone's toes or letting anyone step on yours. And here's the pro tip. A unique, memorable brand equals less confusion, which means happier customers and happier lawyers. Now that we've covered the different types of confusion, let's explore how courts determine the likelihood of confusion in trademark cases. There are several factors they consider. 1. Similarity of the marks. Courts examine how visually, phonetically, and conceptually alike the trademarks are. The more similar they are, the more likely confusion can occur. 2. Strength of plaintiff's trademark. Well-known brands like Apple or Nike receive stronger protection, meaning their trademarks are less likely to be confused with others. 3. Actual consumer confusion. Evidence that consumers have mistakenly associated the two brands can greatly strengthen the case for infringement. 4. Marketing channels. The methods used to advertise the brands are important. If the brands use similar advertising strategies or target the same customer base, the chances of confusion increase. 5. Defendant's intent. If the defendant deliberately copied the mark, this can strengthen the infringement claim as it shows intentional misuse of the trademark. 6. Degree of consumer care. For more expensive or specialized products, consumers tend to be more careful in their purchasing decisions, which can reduce confusion. Courts take this into account when deciding the likelihood of confusion. In addition to these factors of confusion, there are two more important aspects to consider in trademark infringement. Number 4, use in commerce. The defendant's use of trademark must have a tangible impact on trade for the infringement claim to be valid. Simply using the mark without affecting commerce isn't enough. Number 5, trademark dilution. Even without confusion, famous brands can take legal action if their trademark's distinctiveness is weakened, that is blurring, or their reputation is harmed, that is tarnishment. Now let's take a look at the legal claims that plaintiffs can bring in case of trademark infringement. There are several key claims to be aware of. 1. Unfair competition. This occurs when one party gains an unfair business advantage by using a trademark that causes confusion among consumers. 2. Trademark dilution. This happens when a famous brand's uniqueness is weakened either by blurring or tarnishment, as discussed earlier. Number 3. Unjust enrichment. When someone profits unfairly from another brand's reputation by using its trademark without permission. 4. False advertising. This involves misleading customers in a way that creates confusion, often through deceptive marketing practices. And 5. Harm to reputation. When the misuse of a trademark damages a brand's image or goodwill, it can harm its overall reputation. Now let's explore the defenses available if someone is accused of trademark infringement. Number 1. Parody. If the use of the trademark is humorous and unlikely to confuse consumers, it may be protected under the First Amendment as a parody. This applies for creative expression without violating trademark rights. 2. Fair use. There are two types of fair use defenses. Descriptive fair use, which occurs when a trademark's ordinary meaning is used rather than its brand identity. For example, calling a juice sweet tart even though there's a candy brand with the same name. Or nominative fair use. This happens when a brand name is used to describe its product, like a news report mentioning Starbucks without implying affiliation. 3. Laches. If the plaintiff waited too long to bring a lawsuit, the defense of laches can be invoked, arguing that the delay in suing should bar the claim. Number 4. Estoppel. This defense applies when the plaintiff previously allowed the use of the trademark and by doing so may be prevented from suing later on. 5. Unclean hands. If the plaintiff acted dishonestly in their business practices, it can be argued that they come to court with unclean hands, making their claim invalid. Number 6. Challenging the trademark's registration. The registration of the trademark can be disputed, particularly if it was recently registered with the argument that it shouldn't have exclusive rights. These defenses provide a solid foundation for challenging a trademark infringement claim and can help protect a brand or business from unwarranted legal action. Now, let's look at what happens if the plaintiff successfully proves trademark infringement under the Lanham Act. In that case, the defendant could face serious consequences. First, there could be a court order to stop using the mark, which may happen even before the case is fully resolved. Additionally, the defendant may be required to pay monetary damages covering the financial losses caused by the infringement, and in some cases, these damages could be tripled. The defendant may also be liable for any profits made from the infringement, which could be handed over to the plaintiff. In rare cases, the defendant could even be ordered to pay the plaintiff's attorney fee. Losing a trademark case isn't just about changing a name. It can lead to significant financial and legal consequences. And there you have it. Trademarks are more than just logos or slogans. They are the very foundation and heartbeat of a brand's identity, safeguarding creativity and ensuring fair competition. Whether you are a small business owner or a global corporation, understanding trademarks is crucial to protecting your unique ideas and avoiding costly legal battles. So the next time you spot that iconic swoosh or golden arches, remember, behind every great brand is a trademark working tirelessly to keep it one of a kind. Remember, your brand is your legacy. Protect it with a trademark and let it shine. Thanks so much for watching. Please do consider subscribing and don't forget to like and share with people you think might need it, and stay tuned for more insights into the world of intellectual property. And until next time, safe travels!